I'll be direct and tighten this up because by property 3, the pattern matters more than the excuses. Short answer. First, at property 3, the alleged tenant still has no protected tenant rights related to the garage or altered room, and his behavior actually weakens any claim he might have to broader tenant protections. Even if there is a letter saying he rented a downstairs bedroom, that does not legalize the garage alterations, the additional room he mocked code enforcement about, or any plan to rent that altered space to someone else. Those are separate legal issues, and he loses on all of them. Number 1. Separate the issues. This is critical. A. Downstairs bedroom. Per the letter, if there is a letter stating he rented a downstairs bedroom, that could establish a limited residential tenancy, but only for that bedroom. If the bedroom is a lawful dwelling space, the property is zoned residential, and the owner consented to that specific use. That would give him basic tenant rights only as to notice requirements, unlawful lockout protections, limited due process. It does not give him carte blanche over the property. B. Garage alterations, no permits. The garage is a different universe legally. For the garage, no permits, no certificate of occupancy, no residential approval, alterations done by the occupant, not the owner. That means illegal construction, illegal occupancy, no tenant rights attached to the garage at all. Even a lawful tenant cannot convert space, especially not into a rental unit. Number 2, mocking code enforcement on video hurts him. This is not just cringe, it's legally stupid. That video is evidence of knowing violation, willful noncompliance, intent to create an illegal dwelling, possible intent to illegally sublet. That destroys any argument of, I didn't know, I thought it was allowed, I was just fixing things. From an enforcement standpoint, this shifts the case from oops to deliberate violation. 3. Planning to rent out the altered room. This is where things get worse for him. Planning to rent an illegally altered room means operating an illegal rental, acting as an unlicensed landlord, possible consumer fraud, zoning violations, building code violations, fire code violations. A tenant cannot legally rent out space they do not own or have lawful authority over, especially space that is illegal to occupy. No tenant rights protect this behavior. None. Number 4. The bedroom tenant argument does not save him. Even if he was a legitimate tenant for the downstairs bedroom, tenant rights do not extend to unauthorized areas. Tenant rights do not authorize construction. Tenant rights do not override zoning or permits. Tenant rights do not allow creating additional dwelling units. Courts draw a hard line here. At best, he is a lawful tenant in one room and an unauthorized builder occupant everywhere else. Number 5, code enforcement's position, property 3. Code enforcement will cite the property owner, again, order removal or restoration of the garage, document the video as evidence of willfulness, potentially escalate penalties faster because this is a repeat pattern with the same individual. They do not adjudicate tenant rights. They do not care about his online narrative. They care about compliance. Number 6, does the letter change his rights? Only narrowly. The letter might prevent an immediate lockout of the bedroom, require notice if the owner wants him gone from that room. It does not legalize the garage, stop code enforcement, shield him from removal from the garage, protect him from being barred from construction, allow him to rent space to others. Number 7, his rights summed up precisely. He may have limited tenant rights to a lawful bedroom if proven. He does not have any right to alter structures, any right to live in the garage, any right to convert space, any right to rent out rooms, any protection for illegal occupancy, any defense against code enforcement. Number 8, pattern matters. 3 properties, same behavior, same violations. Public admissions on video. If this ever lands in court or before an administrative judge, the pattern alone destroys credibility and intent defenses. Bottom line. Even with a letter claiming he rented a downstairs bedroom, garage alterations remain illegal, no tenant rights attached to those spaces. Mocking code enforcement is self-incriminating. Planning to rent illegal space is a serious escalation. He has narrow, limited rights at best, and none where he's causing the violations. If you want, next I can lay out how an owner should sever the bedroom tenancy cleanly. Explain how this pattern can justify faster enforcement. Break down civil versus criminal exposure for illegal renting, or map how his own videos undermine him legally. Say which direction you want to go.